Good evening, everyone, and welcome to the Henry Schein Dental Academy webinar series. My name is Adam, Marketing Specialist, and I'll be your moderator. Tonight, we're welcoming Jill and Sasha from HR for Health as they dive into how to avoid common HR pitfalls. Before we get started, I do want to note that we have some scenario-based poll questions during the webinar today, so please feel free to answer the questions. All answers are completely anonymous. At any point during the webinar, we, of course, encourage your participation outside of that as well. If you have any questions, please type it into the Q&A section of your control panel, and we'll answer them live at the end of the presentation. Henry Schein is not offering CE credit for viewing or attending this presentation live or on demand. And this webinar is sponsored by Henry Schein's Dental Business Institute, as well as HR for Health. Jill and Sasha, welcome.
Hi, everyone. So tonight's webinar is inspired by the show The Real World from MTV. So while I was not supposed to watch MTV while I was growing up, I always tried to sneak glimpses of certain shows, and The Real World was always one that I wanted to be able to watch because it always has that drama, the good storylines, the juicy details of everything, all the ins and outs of what's going on in the house. And you know, all joking aside about the reality of dental practices, we know that there's a lot of this going on as well. And so what we're doing tonight is going through actual real world scenarios that come up with our team. And Sasha, one of our HR specialists, that all she does all day long is talk with our clients through these certain scenarios. We're going to go through all of those, and we're going to make it fun with, as Adam mentioned, some interactive polls to kind of start with, and then go through some of the more common HR scenarios. And again, the reality is our team is listening to these situations come up every single day. Sasha, all she does all day is sits on the phone or answers emails or answers tickets with these scenarios. And I think that a lot of people that might be tuning into this webinar, we are all guilty of the natural human reaction of that won't happen to me. And it's really easy to go through our day-to-days like that. And until it does, and this is what we want to bring to the table, this is truly what's happening. These are the common mistakes, the common scenarios, and maybe even some crazy dramatic ones just to throw in there for some fun. One really important note, all names and any incriminating details have been changed of these scenarios that we brought from our clients. So don't worry. If you think it's you, it's probably not, because it does happen so common to a lot of people. So we promise everybody's identity is safe. But going back to what are we going to go through? We're going to really be talking about what's coming up day to day. And at HR for Health, we have been for years, our role and our purpose is to help doctors through these hard situations and give them the tools to be able to handle them with confidence. And so we do that a couple ways. You're going to hear Sasha tonight mention some software components, because the reality is our team uses this software that we have to help them do their job. When a client calls in and asks, how do I handle this scenario? There's almost certain, Sasha will tell you, there's almost certainly a documentation follow-up that either should have happened before or needs to happen afterwards. And that's really where the software comes in to help. So we will be mentioning that, as well as some ways to make sure that you can do it even if you are not an HR for Health client, that you're able to document and support the evidence needed should these scenarios go wrong, you know, the way that we've seen them. So what are we going to go through tonight? First and foremost, we are going to test your knowledge. So all of you that are on this call, we're going to throw some wacky situations your way, of real life situations that have come up for our team. And we want to know from you, how would you answer it? How would you handle it? And there's not always one black and white answer. And we'll talk through the different ways that you can handle scenarios, because sometimes there's the safer way and then there's the safest way. And so that's what we want you all to walk away with tonight. Then we're going to go into some of our more common, more general situations that come up. And Sasha's going to talk through how we advise our clients in handling these. And then at the end, we will be going through your HR headaches. So I really encourage all of you throughout tonight to submit your questions. Nothing's too small, nothing's too big. As I said, this is what Sasha does all day. So take this as a free hour of advice, if anything, of being able to submit your questions, and we will make sure that we get to them. Or if we're not able to get to all the questions tonight, we will absolutely follow up with you. So before we get started, what I want to make sure we highlight in the beginning, I will show this at the end as well, but because you're all Schein doctors working with Henry Schein as a partner of Henry Schein, we always want to give some sort of resource so that you can leave feeling like you have a good next step ahead of you. And so if you text the number 44222 and you text the word Schein risk, all one word, you will receive our 9 common HR mistakes white paper and also a brand new resource, which is our HR savings calculator. And so this actually will give you an idea of how much your time is worth, how much is your turnover costing you, and hopefully help to reduce that number so that your HR is not costing you more than it's needed. And as always, as Schein doctors, as people registering for this webinar through Henry Schein, you are all eligible for a free HR consultation. What that consists of is, what it really is an HR analysis. So our team will walk through with you about 10, 15 questions, not too long, that will give you at the end a score of your risk score. And we want that score to be as low as possible, but depending on that score, our team will help to give you some suggestions and solutions that you can implement almost immediately to help, again, reduce that score. So I'll show this at the end, but always make sure you're taking advantage of all of these free resources. We really want to make sure you're protected day in and day out. So let's jump into it. Adam, I'm going to pass it back to you because we're going to get right into the polls early on. So we want to know, how would all of you handle these real life HR situations? So let's show the first situation. And Adam, if we can pop up that poll. So here's a scenario. A male employee feels ganged up on by our female team. And when trying to give feedback, he gets mad about that. And they tried to meet with him, but he stormed out. So how would you handle this? Are you going to allow the situation to work itself out, act as a liaison for communication between the team, reprimand or terminate any employees that are ganging up on others, or reprimand, terminate the hot-headed employee? The tough one. Take a moment to answer the poll. Adam, I'll let you tell us where we're at with it.
I give it a little more, but I'm seeing
no problem.
Everyone except a few people are answering one answer. So I'm interested to see if it continues.
Oh, and interested to see if it's the right one. Again, there are some gray areas on these scenarios. There's the safer and safest option.
All right, looks like the majority have answered, so I'm going to close that one. Okay. The most popular answer was B, act as a liaison for communication between the team.
Got it. Was there any others that were answered?
The only other one that was answered was allow the situation to work itself out.
Got it. Okay. Sasha, what do you think on this? How did we help them through it?
Yeah, well, a majority of people that chose B did really, really well. So definitely want to act as a liaison for communication when these types of things do occur. So looking at this scenario, there's kind of 2 things that we want to address. So first of all, we have the issue of the male employee feeling ganged up on from the female team. Then you also have the other side of things where this male employee is also receiving feedback, and this person seems a little bit hot-headed, and they also stormed out. So really taking these into kind of 2 different scenarios. And one is that you just need to make sure that as an employer, and to keep a healthy work environment for everybody, make sure that everything's safe and everything's open to communication. It's really important for you as the owner, office manager, to be able to open that channel of communication and make sure that you can help mediate everything going on. So definitely hearing both sides of the story, acting as a channel of communication so that anything can get straightened out, to make sure that any miscommunication as well as the feedback gets through to the other employee. And then also making sure to set these boundaries. So, all at the end of the day, this male employee is experiencing harassment, and that's definitely something that's not acceptable at a lot of practices, and something that is unfortunately happens really often in a lot of these day-to-day scenarios that we have with our clients. So being able to document that conversation as well. So utilizing our software and making sure that you're taking notes to say, okay, we spoke to this employee, we spoke to those employees, got both sides of the story. We're setting boundaries of okay, this is what is acceptable, this is what is not acceptable, and definitely making sure to reference your handbook as well if you have a handbook that talks about harassment, and making sure that you're referring back to what the practice stands for as a whole and what policies you want to be able to set forth. So making sure you set those boundaries and reaffirming what steps that employees should take if they are in this situation moving forward and feeling uncomfortable. So I would say that a lot of our participants did really well.
Awesome. We are off to a good start, but I hope you all know we started with the easy ones. So we'll see how the rest of them shake out. So our second poll is an employee kicked her boyfriend out and he wants to talk to me about her. I don't want to speak to him, but I'm concerned about safety in my office. So do you talk with the boyfriend to hear his side of the story? Do you terminate the employee? Do you allow the employee to take a leave of absence, or do you ignore it altogether? Is this none of your business, somebody's personal life? Leave it as is. So go ahead and cast your vote of how you would handle this.
These ones are a little slower.
I told you they get tougher.
Give it just a few more seconds here.
No problem.
There's definitely two that are in the running. It's like 50-50 between the two, and the others are kind of out there.
Yeah.
All right. In the interest of time, the most popular answer was allow the employee to take a leave of absence, but right behind it was ignore it altogether.
Okay. Sasha, what do you think?
Yeah, so the answer that we definitely recommend is to allow the employee to take a leave of absence. So the reason why the other one was incorrect is because you definitely don't want to get involved in depth like that. So what I mean by that is, we get a lot of clients on the daily. Sometimes they'll say like, oh, my mom or this employee's mom called in to check up on this employee's employment, or, cousins or something. They want to know, facts about the employment, like, are they at work? What's their schedule? What's their contact information? And those are things that you definitely want to keep confidential for the sake of the safety of your employees. So all of your employment records, first of all, definitely need to be safe and confidential between you and the employee. So attempting to not provide any additional outside information to any family and friends to avoid liability is definitely something to consider. So definitely don't speak to the boyfriend or ignore it altogether. You definitely want to be able to create an environment where your morale is up, right? So if something like this is happening to the employee, which could possibly, later down the road lead to harassment, there are a lot of states that have protected leave when it comes to like domestic abuse and things of that sort of nature. So definitely in this situation, we recommend speaking to the employee and let them know of the scenario. Hey, your ex is trying to contact me. We're just kind of concerned. Like, is there anything that we can do? Do you need to take a leave of absence in order to kind of work this scenario out? And hopefully that will be a good outcome at that point. But definitely give them the choice to be able to have that leave of absence, because not only are you thinking about the safety of your practice as well as this particular employee, but you're also, if employees hear about this happening to the employee, that can definitely help the morale boost and show that you care as an owner of the practice.
Awesome. Great. So let's jump into the next poll. So I scheduled someone for a working interview. Her background check showed a 4th-degree assault charge. This goes to court after her working interview. So how do we handle this? Do you cancel the working interview and continue searching for candidates? There's nothing you can do since the applicant has not been convicted. Or do you ask about the arrest and let the applicant explain themselves? What do you think? Go ahead and answer in the polls. How would you handle this?
So while they're answering, we did receive a question on the last scenario that I'd like to bring up since it's timely.
Yeah, of course.
So one of the attendees said, what if the employee is involved in criminal activity? Or maybe that's just a general question. I'm not really sure.
In general or for this scenario? For the working interview, is that where it came in, Adam?
the last one with the boyfriend.
So
Like I said, maybe that's just a coincidence, or maybe that's directed at that. I'm not entirely sure.
So if the employee is also involved in criminal activity along with outside of the situation with her boyfriend, well, I guess let's address that in general.
Yes, and then he said, and he knows something. So what if she's involved in criminal activity and he knows something?
Okay, so the boyfriend has dirt on her and wants to tell the employer about it, is what it sounds like. What do you think, Sasha?
Well, when it comes to this criminal activity, that's also something that you may or may not want to kind of dip your toe into. So it's really not I want to say that it's not your obligation to report anything to the police at that point. If that's something that the employee that the ex-boyfriend wants to come to you about, that's definitely something that, well, you're kind of opening yourself up to liability at that point because you're speaking to them about the employee itself. So if this was something that had to do with criminal activity, first of all, they should be going to the police. So that really shouldn't be going to you. But in general, that really opens up a can of worms for the liability. So just speaking to them in general, really, we don't recommend that.
And I think it actually plays into this scenario a little bit, just about, hey, you found out there's a pending 4th degree assault charge. In general, how you want to look at criminal activity is, does that really affect their job? Does that affect their day-to-day with your office? And in that case, that you can handle it a little bit differently. But as Sasha said, if it's something that has nothing to do with the office, it should definitely be going to the police and not concerning you, because then are you going to make an employment decision based off of it that really you shouldn't?
Perfect. Thank you. Okay. Now to the topic at hand. So this one was relatively close, although there was a clear winner.
Okay.
So the clear winner was A, cancel the working interview and continue searching for candidates. Just behind that, though, was ask about the arrest and let the applicant explain themselves. And right behind that was there's nothing you can do.
All right. So we're kind of all over the board. I told you they would get trickier. So what do you think, Sasha?
Yeah, so the correct answer for this is actually to ask about it and let the potential candidate defend themselves. So the reason why that one is the correct one is that when you run a background check on a potential candidate, and you find something on that background check, it is your obligation to allow this potential employee to dispute and explain those claims. So depending on the severity of these claims, like for example, this one, the 4th degree assault charge, people make mistakes, things happen. Background checks companies can also make mistakes as well. So if this is something that the employee is just like, whoa, I had no play in that, I don't even know where that came from, then that's something that is going to help you out because you did the right thing, you looked into it, and it turned out not to be true. Rather than moving forward thinking that that's actually something that happened to them without the dispute, then that could kind of lead down a dark path. But if this employee does say they own up to it and they say, yes, I did do that, but maybe they're trying to flip their life around, you definitely have a choice. If you're like me, you definitely believe in second chances. There's some people out there that may have came into a run-in with the law at one point, and they're just trying to change their life around. So at this point, it's really up to you. It's just depending on the amount of risk that you are personally willing to take. So along these lines, there's something called a negligent hire. So what a negligent hire is basically something of their criminal activity that they have participated in the past. And at that point, if you hire them on knowing that they have a 4th degree assault charge, and let's say they fight a patient on your premises while they're employed with you, then that can be considered a negligent hire. And that is a whole world of its own of lawsuits and a lot of lawyer fees. So with that being said, we're not trying to discourage you from giving people second chances, but you just have to be careful about, if this person comes back with a background check and that you desire to hire them on, there is a little bit of liability of what could possibly happen on the premises if you do decide to hire them. So there is that little bit of risk with that.
Yeah, I think, and again, it goes back to ultimately, once you allow them to explain themselves, you have the decision to make of, is this truly going to affect their role in my practice day to day? Is this going to affect my practice? If the answer is yes, like Sasha said, there's maybe a little bit of risk there. in terms of the safety of the practice. If it's something that has nothing to do with their day to day, the job market's tough right now. So if they're really great and it has nothing to do with your practice, it wouldn't affect your operation, might be a good idea to hire them. I think in summary, it's really important to have somebody that can help you through these types of situations so that you do get support. And what do you do after you find out what exactly the situation was once the applicant discloses it? All right, great. So let's go on to the next one. So, employee files a sexual harassment claim against another employee, but you find out they are dating. How do you handle this? Do you fire them both, keep them both employed, but look into the claims, fire the employee who is accused of harassment, or ignore it, they got into it themselves? So what do you think?
Seems to be a runaway so far.
Yeah.
It's early. And of course, I know I put it in the chat, but if anyone has questions that stem from these scenarios or you have your own scenarios, please feel free to drop it in the chat in Q&A, and we can, of course, answer that at the end as well. All right, so it's looking like the clear runaway is keep them both employed, but look into the claims. The other three did receive answers, but not nearly as much.
Got it. Yeah. What do you think, Sasha?
Yeah, definitely. Majority of people were correct in that aspect. So the best thing that you can do in this scenario is that with any type of claim, things like sexual harassment can be he said, she said when it first comes through the door, right, and lands on your table. So the first thing you want to do is make sure that you're first of all documenting this individual that is coming in and letting you know, get their side of the story, and then you need to investigate that. So having that documentation from that first person and also having a documentation from that other person, you can find out a lot of things. So with this particular scenario, what had happened in the past was that employee A had filed a sexual harassment report on employee B. So employee A went to their employer, let them know, and then the employer called us to ask for guidance. So we let them know, hey, get both sides of the story, make sure you document that, and then we can go from there and just give us a call back. So they did as such. They had employee A's statement and then they had employee B's statement. And so from what they found out from employee B's statement was that these individuals had been dating, but they broke up recently. And this sexual harassment claim came after they had been broken up. So what it seems like is that in this situation, that employee A since everything kind of went south in their relationship, employee A got a little bit salty, you could say, in that situation, and then decided to file that sexual harassment report. So, and all in all, at the end of that scenario that had happened was, at the end of the day, the employer had a conversation with both of the employees and allowed them to get both of those perspectives, and then have a conversation with them, both setting the boundaries for both of the employees and let them know, hey, we have a zero tolerance policy, whether you're dating or you're not. This is behavior that is not allowed in the practice at all. And since it was kind of a misunderstanding in such a way that it wasn't necessarily unwarranted at the moment when they were dating, it just became a conversation to where they set those guidelines, the boundaries, and what they can expect moving forward. So all in all, it resolved itself, but it definitely would not have been resolved without having the communication and the investigation from the employer.
Yeah, and one important note on this is the two employees were, there was not a power of one over the other. So one didn't have like more of a title or anything like that. So in that situation, again, always call us or somebody when this happens. But that we were able to advise that way because they were in the same position essentially. So there wasn't like a power ranking over the other. All right, let's jump into our very last real world poll, which is an employee comes in behaving differently. Their behavior seems erratic. You believe they might be under the influence. So how do you handle this? Is there nothing you can prove? So there's nothing you can do. They are clearly under the influence, so you must fire them, order them an Uber to go get drug tested, or ask another employee to keep an eye on them. What do you all think?
I feel like this is the hardest one.
We saved the hardest one for last.
We're definitely coming a little slower. All right, let's see here. Looks like we've got two that are close, but one might be a runaway. It's
All
looking like the popular choice is order them an Uber to go get drug tested, but right behind it is ask another employee to keep an eye on them.
All right. Yeah, Sasha, what do we think on this one?
Yeah. So, first of all, when an employee comes in acting erratically, or they're kind of being a little bit different, and you think that they're under the influence, you definitely want to document this behavior. Document. So, so if you have a reasonable suspicion to think that they're under the influence, it's important to note, the date, time, and what their actions are. How do they look? Are they slurring their words? Do they smell like a substance? Things of that nature. Really, really anything that you can kind of use your senses to kind of see. Like if you notice that they're maybe wobbling a little bit, even that, as much detail as possible. The documentation portion of this is the most important, because if you were to send them to a drug test right away, then possibly they can come back later and say, oh, I was discriminated against because I was the only person that was asked to be drug tested. Whereas if you were to document that in the first place, then you have that protection. And if somebody tried to do that, then you can say, no, I have this documentation on so-and-so date stating that you were wobbly, you smelled like so-and-so, and things of that nature. And that is for your protection as an employer. So the correct answer in this scenario would definitely be to ensure a safe ride for this individual. So you can order an Uber for them, and then they can go get drug tested. This can either be an Uber, or you can even ask an office manager or somebody in an entrusted position, such as such, to bring somebody to a drug testing facility to get that result. So when the result comes back, it depends on how you want to go about it, if it's positive or not. If it is positive, it's up to you whether or not you want to fire this individual or terminate them. This is definitely something that you can automatically terminate somebody on the grounds of if they fail this drug test. So the riskiness of keeping somebody who is an employee that has been positive with their drug test is that if you let this one time go, and this happens again, and let's say that they mess up on working on a patient or something of the matter, then there's a huge liability on your part, because you knew that they were positive for this drug at one time and you let it go, and then it occurred and somebody got hurt. So you do have the choice whether or not you want to trust the employee to possibly not do that again, or if you want to fire them on the spot for coming to work inebriated or intoxicated in some way.
Got it. All very helpful. So what I want to jump into now and in the second half is some of our more, not general situations, but very, very frequent that, again, some of you on this webinar might say, are they talking about me? But it's just because it's so common. So I want to jump right into the first one, which is we have clients or a lot of people before they might start working with us that don't realize, hey, my employees are paid per day, or maybe percent production or percent collection, but I pay my employees the same rate every single day. So I don't have them clock in because I pay them the same rate. And why would I have them clock in? And so, Sasha, I want to know how do we advise them on that? What do they really need to be aware of in these situations?
Yeah, so a lot of times our clients will call us with questions about per diem. So per diem employees are non-exempt employees, which means that they have to take their lunch in rest breaks as usual, and they also are eligible for overtime. So it is important to make sure that you are having a timekeeping system with timestamps to be able to calculate that overtime correctly. Because even though you're paying this employee, let's say $500 a day, once they hit that overtime threshold, depending on the state that you are, but over 40 hours in 1 week for federal guidelines, then you need to break that per diem down to hourly so that you can actually pay them the appropriate overtime rate that they are actually supposed to have. And without a time clock system, this can really cause a huge mess and huge issues for possible wage claims and back pay. So if you're just paying employees per day and they're not using any sort of time clock system, you're really opening up a lot of liability for individuals to come back to say, hey, I wasn't paid for overtime, or hey, I worked so and so hours and you're not paying me correctly. And without a time clock system, you can't really prove that. And there's a good chance that the government's going to side on the side of employees because you're not able to produce, you actually clocked out 8 to 5. And that's something that our system is really able to do and also calculate for you is that overtime for per diem as well. So definitely always use a time clock system because you do have to keep track of their hours.
So for any of the people on the webinar that are thinking, okay, I don't do this right now. I might have underpaid my employees. I might be currently underpaying them. I owe them money. What would you say? What are their options to handle this?
Yeah, so you have about 3 options. So the most risky route that you can go with is just ignore it at all. Just completely ignore it, move forward like nothing's happening. But at that point, you do have the most liability because just because it's been going well and smoothly for a couple years or many years or so doesn't necessarily mean that your employees will one day get smart and do their research, and then you have a problem on your hands. Mm-hmm. So the medium type route risk for that would be to continue compliance moving forward, but then kind of ignoring the past. So this one's medium risk just because, you're going to be super fine moving forward, but then you're just going to be ignoring the penalties you could and claims that could occur from the past when you weren't in compliance. And then the best option for you that has the least risk would be to pay the entire amount that you're supposed to owe them in one lump sum and to be compliant moving forward. So, if you have some sort of time clock system or maybe like a paper time clock, or you can just kind of guesstimate the lump sum that they should be owed for the months or years that they've been with you, and then move forward with the compliance. That's the best route that I can recommend.
Got it. Yeah, and I think regardless of what route you take, hopefully it's either 2 or 3. Definitely want to fix it moving forward. And if you are not an HR for Health client, or if you are, realize that our time clock is built for dental practices specifically. So we will keep track of the per diem rate. If they go into overtime based on your state and federal laws, we'll do that overtime calculation for them. And one other thing I do want to note that we hear a lot is if they don't work the full day, I'm going to deduct the hours because they didn't work the full day. I'm going to deduct from that $500 I pay them flat rate. And you can't really have it both ways. So make sure you are paying them for the full day, even if they don't work full 8 hours or whatever it is that they're scheduled. And then if they go into overtime, make sure that you are paying them that, doing that calculation of breaking it down to their hourly rate and then paying them time and a half. So if this is something you're doing yourself using Dentrix or something like that to track time, make sure you're breaking down that daily rate into what their hourly rate would be, making time and a half from that. If you're an HR for Health client, you're using this, it does it for you. And also same with percent production and percent collection, just to make that note. So really anybody that is not a salaried employee that's truly non-exempt should be using the time clock.
I've actually got a question here, if you don't mind.
Yeah, of course.
So I pay employees hourly, but when time management becomes a performance issue and employees are slow to clock out at the end of the day, do you have to pay them beyond the agreed upon time scheduled?
It's almost like this person got our presentation beforehand and knew what we were going to go over. We do have a full scenario around this, and we will get to this in a bit in a little more detail, but short answer, yes, you do need to pay them for the hours worked. So we'll talk about some strategies of how to deal with that. So our second situation, really common right now, right, Sasha? My employees are taking too long to put on PPE. Do I have to pay them for this time? And what do we say? Oh, sorry.
Yeah, definitely. So especially in times of COVID right now, you're putting on a lot more PPE than usual. So I can definitely understand that this can be a pain point for a lot of our clients, and a lot of our clients have been asking this question as well. So anything related to an employee's job or the duties that they perform at work have to be compensated for. So what I want to get into is kind of the voluntary criteria of what you don't really have to pay for. So PPE is something that you do need to compensate them for because it's not necessarily voluntary. And what really makes a scenario or a part of their job really truly voluntary has to meet these all four criteria. So the first one is that their attendance is voluntary. It is outside of their normal office hours. The training is not directly, or the act in and of itself is not directly related to the employee's job, or the employee does not perform any productive work. And it has to meet all four of those criteria to really be truly voluntary. And at that point, if they do meet those criteria, then you wouldn't have to pay for it. But unfortunately, PPE falls within those categories, and they have to wear PPE to do a part of their job. So it does have to be compensated. So if you have an employee that may be lingering too long with putting on, taking off their PPE, and they're kind of dragging out maybe overtime at the end of the day by putting it on and taking it off too slow, you can treat the scenario as any other task of their job, because it is a part of their job technically, even if it's just putting on a gown or putting on an extra mask. So if that were to occur, definitely have a conversation with this employee to address the situation. Say, hey, I understand we're putting on a lot more PPE than usual, but I've been noticing that you're taking 10 minutes as opposed to a lot of people that are taking 5 minutes. Is there something that I can help you with? Is there something that can make the process a little bit more smoothly for you? Kind of gauge the situation and kind of understand what's going on a little bit better. Definitely document that as well. And if that individual keeps abusing this time and, after you have that conversation, they're not listening to you and they just keep they don't really have a legitimate reason for taking so long for putting on their PPE, then you can take disciplinary action at that
time. Awesome. All right, our next scenario. So what happens if an employee claims that they weren't paid for all hours worked? So I know that we've heard a lot of scenarios of paper timesheets. My employees are keeping track of their time on paper. If they forget to put their time down, I tell them to write down the hours and they'll get paid for them, but maybe they never do. And so what's our best practice here? What do we recommend in terms of handling paying employees and what to do if they say they weren't paid for all the hours that they worked?
Yeah, definitely. So to be blunt about it, paper timesheets are very outdated, and you definitely want something a little bit more solid than that, because having paper timesheets and having employees write down lost hours just in a loose leaflet or a piece of paper opens you up to a lot of liability, especially if maybe you forget to put in those hours at one point. Or maybe in a paper timesheet, the employee's hours are always on time and consistent, so like 8 to 5, when we know in reality it's not necessarily always that consistent. So you definitely want to have an accurate time system that needs your approval for any type of editing, just because fabrication of timesheets unfortunately is not uncommon. So having a time-stamped timekeeping system also allows for you to protect yourself. We talked a little bit about wage claims earlier. So if an employee is claiming that they're not being paid the wages that they're actually owed, you're able to combat that and to dispute that with the fact that the timesheets say XYZ and that's that. We did have a situation at one point where an employee claimed that a manager was taking away hours from their timesheet. But because of our software, we were able to help them out in that situation and do a timesheet audit to actually see who was putting in the timesheet, who was editing the timesheet, when, where that happened, and have a clear audit trail of where things happened and occurred, and who input that edit, and also who approved that. So we were able to find out that actually the employee was adding unauthorized hours that they actually didn't work. So that was one of the scenarios that we really successfully used our time sheet system to be able to kind of backtrack and see what happened in that scenario. And in accordance with that as well, you definitely want to have a handbook policy in place that states the employee's responsibility to ensure that the time is accurate and to communicate to the appropriate person, whether that's the office manager or the doctor directly, if there is a problem or a discrepancy in the timesheet.
Yeah, I think that's really important. And the handbook pairing that with a bulletproof timekeeping system, even, Dentrix or EagleSoft, depending on what practice management system you're using, that audit trail will definitely show a manager changing the time, even if the employee asks for them to do it. So it is really important to have that trail to protect yourself and then be able to use your handbook, because the reality is it's on the employees to make sure their time is correct. But if you're not using a system that allows them to make sure their time is correct, it kind of makes it hard to hold up that end of the bargain. So really important to make sure at least it's digital, but ideally one that's going to show a very clear audit trail of usernames, what they're doing, who's approving, who's changing. So there's no question, so that when you do need to use that paired with your handbook, it's not a dramatic situation. It's just very objective of here's how we handle it. All right, our next scenario. So what do we say when a client calls us and says, I don't know, an employee is absent all the time? What do we ask? What do we say to them? What's the first thing you would say, Sasha?
Yeah, so definitely want to ask them a couple questions. So the first question I want to ask them is, do they have space to improve? And the second question is, have you spoken to them about it? So whether that be, excessive absenteeism, or maybe they're not really doing their work all the way. They're doing it maybe like 70% rather than 100%, which is what you want. The first thing I'll really follow up is, have you asked them about it? Have you had a conversation with them? And a lot of times when I talk to my clients, and a lot of them will say no. And then at that point, I'll say, well, they can't really read your mind. So definitely have a conversation with them first, and be explicit about what your expectations are that you're setting for this employee. Because even though, yes, maybe the tasks are listed in the offer letter, in their job description, but sometimes employees may need a little bit of a reminder. So if you're not being vocal and telling them, hey, you're not doing X, Y, Z right, they won't know, and they'll just continue to do what they're doing because they think what they're doing is right, because they have not been corrected. So at that point,
what if a client says, I want to reduce their pay, or I want to reduce their hours as a way to deal with this performance issue? How do we handle that?
Yeah, so if this is kind of a reoccurring thing, you've spoken to them about it, you have documentation of it, and you think that after, let's say, like 6 months, they don't have any space to improve. That's just a general number I throw out there. If you think that they really don't have the capacity to improve at that point, then you definitely could, as long as they're not in any protected classes, such as they're pregnant, they're disabled in some way, or they're of elderly age, then you definitely can reduce that pay. If they're consistently not performing, after that coaching, like I mentioned, you definitely can. You could just make sure you need to document the reason why you're reducing their pay for their performance issues. But you do have to be aware of the risk factors. So there's something called a constructive discharge, which basically means you're trying to get the employee to quit. So a lot of times when we see constructive discharge is reducing pay too much, taking them off the schedule from 5 days a week to 1 day a week, things of that nature that actually make it really hard for somebody to make a living off of the wages that they're earning from the practice. So constructive discharges are a very big claim that can be a long and expensive lawsuit for you. So when you're reducing the pay, you would just want to make sure that it's an appropriate amount to reduce that, and not such a crazy amount to where it turns out to be a constructive discharge, they end up quitting, and then you have a lawsuit on your hands. Even though that's not the way that you're construing it as, and you're not trying to make them quit, it could be perceived as such and could still make a claim. So definitely make sure to have this conversation with the employee as soon as possible. And if you do it, and if you decide to want to move forward with the reduction of pay, definitely do it as soon as possible. because we have seen so many scenarios. I can't even tell you how many scenarios that have come about where doctors kind of drag their feet on it. They, try to wait a little bit too long, and then they finally say, okay, I want to reduce your pay, or I want to terminate this person. And then suddenly the employee is protected. Suddenly they become disabled from an accident, or suddenly they're pregnant. And then you have your hands tied and you have a whole other scenario on your hands.
Yeah, so documenting in real time, super important. And having that be date and time stamped with ideally electronic, so it's all in one place, so you know where to find it. And like, I think Sasha's made a great point that cannot be stressed enough of your employees should know that this is happening. They should know you should be having these conversations and following it up with documentation. So ideally you have a system that has all of that in one place and they can actually see the documentation if it's appropriate. In our system, there's different options. You can keep it private. You can show it to them. You can also ask them to sign something. So depending on the severity of the issue, you can appropriately document it. But please just make sure to document things, because it's always like, I'll do it tomorrow, and then it's too late. So looking at our next scenario, so paying out lump sum PTO benefits at separation of employment. We get a lot of questions about what should I be offering in terms of PTO and sick and vacation. But we have clients that, PTO and sick and vacation are a recruiting tool. Absolutely. It makes your practice look more desirable in terms of employment. But because of that, we do see clients that try to get creative. And there is a way to get creative, but to a point. I think without putting yourself in a situation where you're open to liability. So I think, we've had clients say, I want to give my employees their PTO all up front, but when I fire them, I want that to turn into an accrual, and then I just want to pay them what they would have accrued up to this point. So that's one example. What do we say about what are the rules? What do they need to know, Sasha?
Yeah, so it really depends on the state that you're in. Some states are a little bit more stringent than others. So I would definitely recommend looking into that or asking us about that as well. So having an intricate or a confusing policy, as you mentioned, is going to seem pretty uncompetitive, just because of the fact that it's going to take too much of brain power to really dissect and understand, okay, what is this saying? And when employees see their offer letter, what they're really going to be looking at is how much they're making and what benefits are they going to have. So if you make it too complicated to the fact where, okay, I'm going to give you a lump sum, and then when you try to leave, it's going to be prorated, then it becomes a really big confusing thing, because then they're assuming they're going to get something, and then they're not getting that in the end. So definitely having something too intricate or confusing can make you seem a little bit more uncompetitive, and can cause can create a lot of disgruntled employees, just because a lot of employees don't understand how they accrue or how their benefits actually work in the long run. So let's take, for example, states that see PTO or vacation as wages earned. So this is places such as California, where something in that scenario would not be compliant. So when considering something that's wages earned, if you are giving them a lump sum upfront and then you want to switch that to an accrual basis once they leave, then that's considered taking away wages earned, which could definitely be a big no-no in these types of states, because that is a huge risk for wage claims, and even waiting time penalties on top of that if the state has that. And in California, that is a full day's wage up to 30 days on top of what you actually owe. So that can really pile up, including that, everything that you owe plus lawyer fees. So that is something that does not look pretty to a lot of our clients, and something that they definitely want to avoid. And a lot of confusion that we have for our clients as well is the difference between a lump sum and an accrual. So the really difference between that is that a lump sum is something that is given upfront. So depending on when you want to start the benefit, let's say after 1 year of employment, employees will get 40 hours per year. So once they hit their anniversary, they'll have 40 hours for the rest of the year to utilize until their next anniversary rolls around, where that will start over again. And then the difference, in contrast to that, is the accrual method. So instead of getting that lump sum upfront, once they're eligible to start accruing, it depends on how you want them to earn it. So the most common out of all of the accrual methods, and the one that I recommend the most, is going to be the per hour accrual. So the per hour accrual is earned per hour as they worked. So, let's say that for California sick leave, just an example, is they earn 1 hour for every 30 hours worked. So for every hour, the calculation will come out to 0.0334. Not to get super technical, but that's the amount that they're going to be accruing as they work 1 hour in a day.
Got it. Yeah, and I think a lot of people struggle with that tracking of, I would love to have them on accrual because I don't want to have to worry about paying them all this vacation or PTO at the end of the year when I terminate them. And so getting a system that can track that is really important. We do that as they work. They just get their hours and you don't really have to worry about it. They're just accruing based on whatever your policy says. So it doesn't, there are systems out there that can absolutely help you to do that. And it can offset that cost potentially of having to pay out a lump sum of vacation or PTO right up front. All right. So our next scenario, so here's our most common one, I think, is no matter where you are in the country right now, overtime is a headache. We know that. And so this is for sure the most common question or situation, frustration that we know that you are all feeling. And so clients say to us all the time, my policy says I do not pay overtime, or I don't authorize overtime to be worked, so I don't pay it. And so how do we handle that? How do we help them?
Yeah, so it's a really common misconception that if it's an unapproved overtime, that you don't have to pay it. But the truth of the matter is that there is no way to avoid overtime, unfortunately. So if employees do work unauthorized overtime, unfortunately, that is something that you do have to comply with and do have to pay in accordance to federal guidelines. But the real question to ask is, why is this person getting overtime? Are they really abusing the system, or is this a performance-based issue? Are they taking too long to write their reports up at the end of the day, and that's why they're doing overtime? And that's something that I definitely recommend looking into, and on the smaller level, to rather than getting mad at the overtime, understand why they're getting the overtime first. So if they're continuing to work this unapproved overtime, definitely speak to the employee, understand, hey, why is it taking you, an extra 15 minutes at the end of the day, an extra hour at the end of the day to finish up all your work? Is there something that we can improve on in that area? Or is there something that I can help take a load off? Things of that nature. So while unfortunately you can't avoid it, you can definitely try to correct that behavior. And then hopefully that will bring down the unauthorized overtime amount.
Yeah. And what is so common as well is that you are disciplining the employee inadvertently by not paying them for the overtime. And I think that it's really easy, just like, I'm not going to pay you, but discipline them accordingly, discipline them actually how they should, write them up, hold them accountable to your policies, but still pay them. It's definitely less of a headache. And I think what's also difficult is, depending on the timekeeping system that you're using, you really don't know when the overtime is being worked until payroll. And so with a system like HR for Health, you're notified in real time if an employee clocks in early. We send you a report every day of who worked overtime that day. Also tardiness, we know that that's an issue. So we're going to alert the employee and you when they're tardy. So just all these little things that add up over time. You don't have to necessarily wait until payroll. You can address it that day or the next morning and say, hey, you worked unapproved overtime. And also explaining, if you need to work overtime, this is how I need you to communicate with me that you are going to work it. So everyone is in the know if it does need to happen. All right, our final scenario before we go to more questions is, do I have to give sick leave to part-time employees? Really common. Do I have to give them vacation? But more so, do I have to give them sick?
Yeah, so in this scenario, there are certain states and even certain cities that give specific sick leave guidelines. So for the most part, most of the sick leave policies do apply to all employees, which include full-time and part-time employees. So the short answer to that is yes. If your state mandates it, most likely it's going to be applicable to part-time employees as well. So the good thing about these policies, though, is that you don't have to necessarily give the accrual amount in the same way. So what I mean by that is there's a certain amount that all employees are supposed to have. Let's say that's about 3 days or 24 hours, right? So you have the flexibility to choose whether or not you want to do that in a lump sum or as an accrual. So, and you can change that up for full-time and part-time employees. Typically what's easiest and what we do recommend is putting your full-time employees on a lump sum basis, which means they're going to get that 24 hours up front when they start their employment. And then they have that to use till the rest of the year up until their next anniversary. And then putting your part-time employees on the accrual basis. And the reason for that and why I recommend that for part-time employees is that if you have an employee who's part-time, let's say they only work 1 day a week, and you're giving them a lump sum up front, you're basically giving them the 24 hours right away, and then they can take those 3 weeks off right away, rather than the accrual method where they actually have to work to be able to accrue this sick time. So, for example, if they earn it for 1 hour of sick time for every 30 hours work, they have to work 30 hours in order to even get 1 hour of sick time. So in that sense, it kind of balances it out so that you're not giving too much time to your part-time employees right away, but you're also providing that amount upfront for your full-time employees who are there on a daily basis.
Yeah, and one additional note on the sick leave, if you're in a state that has a sick leave law, and there's a lot these days, all the way from New York, Colorado, Connecticut, Oregon, Washington, Nevada, you name it, it's probably going to become a federal law at some point, I'm sure. But it's not just giving it to them. You definitely need to track it. Every sick leave law, no matter what the state is, in some variation says employees have to be able to access their hours whenever they want. They basically need to know what their balances are. And so using a system that's going to show them those hours is really important. So like in HR for Health, if I'm an employee, I can see exactly what I have available, request it right through the system. It pulls out from my balance. So that's really important in terms of the tracking. And we talked about the accrual, how as they work, it can just accrue in the system. But it's not just tracking it. Of course, on top of it, you need a handbook policy that explains exactly what they're offered. There's usually wage and hour notices for each state that you need to give them. So if you're not sure what that is, at the end, we're going to show our contact information. Please make sure you reach out to our team just to be buttoned up. I think that there's a common misconception of I just give them the hours or I pay them out the hours for the year and I don't really worry about it. And unfortunately, it's not that easy. So please reach out to us as you have questions. So as we wrap up, I just want to remind everyone, you can text the number 44222 and text the word Schein risk. So you'll get our 9 common HR mistakes white paper, also our HR savings calculator. So really important so you can see what am I actually spending when it comes to my HR every year. And then last but not least, our team can do that risk assessment, that risk analysis for you. Sasha's talked a lot about where's your risk level at? How can we lower that? So that's a part of that risk assessment that our team can walk through with you. As a reminder, this is what HR for Health does. We are a full suite of solutions. We do not just do handbooks. We don't just HR advise. We do everything together because the software, the handbook, the documentation that comes with that, the HR advising to walk you through the scenario, they're all so important that they all come together to help keep you protected. And it also gives your employees the type of experience at work that they are looking for. So we get a lot of questions right now of, I'm struggling with retention, I'm struggling with hiring. And it's really important to look internally at what systems are you giving them? What transparency are you giving them? As consumers, they're working with Amazon. They can order something. They have full transparency of when the package is down the street. And so if they can't even open up and see their employee handbook digitally whenever they want, it's, that's a very big disconnect compared to what they're used to as a consumer. So just something to think about. This isn't a webinar about retention, but I have seen some questions come in about that. And how do I retain employees? Giving them a system to give them full transparency of their employment is definitely the first step in that direction. So on that note, if you have any questions, if you would like to schedule time with our team, feel free to go to this landing page. Adam, I will kick it back to you to see if we have time to go over any questions. I also want to note our team will absolutely reach out to you if you have questions that we weren't able to get to.
Perfect. Thank you. Yeah, let's knock out a couple here.
All right.
So what can you do when an employee forgets to punch out or punch in after a break?
Yeah, definitely. Yeah, that's something that our system is actually able to do. So it happens. I mean, I've done it before as well on accident. Is that you're able to go back and edit these timesheets. And it's going to be the job of either the doctor or the office manager to approve those timesheets. So it's not automatically going to be approved right away. But that is something for review for the upper management to utilize and see whether or not that seems accurate or not. And then they will be able to make that decision there.
Yeah, but we also tell a lot of the times when our new clients transition over to our system and they're like, I'm just really tired of the timesheet edits and I really want to reduce it. That's a part of their job. And in your policies, in your handbook, which we're going to give to you that says you need to make sure you're clocking in and out correctly, that allows you to hold them accountable from a performance perspective. But also we usually say, give them a 2-week grace period. It's almost like you can blame switching to the HR for Health system, even though it's been going on for years, of, all right, we just switched to a new time clock. We're going to give everybody 2 weeks to really get adjusted. And then after that, we're going to start holding people accountable. And usually we see you write somebody up once and the behavior stops because they see that you're serious about it and you're actually paying attention to their hours now.
Cool. So on that topic as well, our employees clock out for lunch. However, they're now finishing their lunch in 15 minutes and they're clocking back in right after that. I'm guessing 15 minutes is probably not a long enough break. What do you think?
Yeah, definitely. So this one can be a little state specific as well, but I can just touch on it generally. So depending on the state that you're in, some of them have a little bit more stringent laws and specifics on how long they're supposed to take their breaks. For example, California, you have to take at least 30 minutes to really be a correct meal break. So at that point, that really is just something that you need to address with your team and let them know, hey, we set these standards for how long you're supposed to be out for. Ideally, should also be in your handbook as well, which is what they sign in the beginning of their employment. Say, hey, I understand and I really appreciate that you were so willing to get back to work and even willing to cut your lunch break a little bit short. But, in the interest of your health, your rest, as well as maintaining compliance, you definitely do have to take the minimum amount of break, which varies by state. So having that conversation with them and making sure that, you're keeping yourself protected and then also showing that you care about them by saying, hey, take a break every once in a while.
And you're also allowed to say, this is our lunch period. So even as long as it's in accordance with state law, you could say, everybody takes an hour lunch break. And you're allowed to hold them accountable to that. So this is also a strategy to help reduce overtime. If they're only taking 15-minute lunches and you're scheduling them, assuming that they're going to take a 30-minute lunch or an hour lunch, it definitely adds up for the week, for the hours that are accumulating up to the overtime. So all really important to keep in mind and absolutely something you can hold them accountable for. Just want to make sure you have that in your policy.
What would you say is the best way to handle an employee complaint against their supervisor who claims has been unreasonably angry in emails about job performance issues?
Yeah, so being open with that communication. So one thing that's a part of our handbook is the open door policy. So being able to go to any supervisor, whether that be the owner and multiple supervisors at a practice, is something that you want to have. So if you have, and that's the reason why it's in place, is because sometimes employees and supervisors may butt heads, and there may be some claims and complaints in that department. So being able to be open to listen to the complaint that's coming in, making sure you document that, get the full details of kind of what's happening from their side of the story, and then also going to the supervisor side of the story without naming any names, being pretty general about it. Just say, hey, I understand that that maybe there's like a little bit too much on your plate lately. Like, are you doing okay? I've been kind of noticing that you're a little bit more hostile. Is there something that I can do, or is there something going on that I should know about? And making sure to document that as well. A lot of times miscommunication happens, and maybe, a lot of people have different talking styles, and maybe one person's aggression is just, the way somebody talks on a day-to-day basis, but maybe somebody else isn't, the receiver isn't used to having that kind of type of conversation and interaction. So at that point, when you come to having both of those conversations, a lot of times it can also be good to have a conversation and mediate between them so that they can also have a conversation between them and see how they can also work out, with also you being present at that moment to see if there's a way that you can work it out, or if there's a way that you can clear the air. And at that point, it depends on the situation at hand, and if that evolves into a further thing. But in general, make sure you have open communication and then documentation.
Yeah, we always say it's not illegal to be a bad manager. So it's just that fine line of, is it pervasive? Is it creating a hostile work environment? Or is it maybe just some coaching for the manager? And maybe communicating via email is not what works for this duo. Maybe they need to be communicating verbally to be able to pick up the social cues. So like Sasha said, just understanding from both sides what's going on, and then being able to help them adjust so that it doesn't snowball into something where it could be a hostile work environment situation or the employee feeling that way.
Great. So we'll do one more tonight. I do want to mention this webinar was recorded and will be available within 1 week of today. So keep a lookout for that if you want to rewatch or send it to your team. So this last one here is basically just asking for a little further clarification on sick leave and PTO. Are they the same? Are they different? And or can they be combined?
Yeah, that's a really great question. And that's a really common question as well. So PTO is something that really encompasses paid time off, whether that be vacation or sick leave. So PTO, we kind of see as one whole policy that you usually just have that in your handbook. And that encompasses all of any paid time off, sick, vacation, whatever. On the other hand, sick leave, you can also have a policy that's sick leave separate from vacation. And that's typically what we recommend, especially if you live in a state or city that has specific sick leave guidelines. Because when you have a PTO policy, you can't really customize it to the extent that a lot of practices want to, especially when you have to meet the guidelines of a sick leave policy. So when you separate those, you have the sick leave policy in one bank, and then you have the vacation policy in another bank. The vacation policy, depending on your state's laws, you have a lot more freedom with. Whereas the sick leave guidelines, you do have to be a little bit more stringent, and you have to follow what is mandated by the government, or state government or city government in your area. So to recap, PTO is an overall encompassing of sick leave and vacation and personal leave in one bank. And you can also have a separate sick leave versus vacation policy in your handbook. So could be the same depending on how you want to keep them together, or if you want to separate them.
Yeah, and I think it's really important, if you are in a state that has sick leave, we highly recommend separating them, just because when it's PTO and all the hours are lumped together, you basically have to treat all those hours like they're sick leave. So you can't ask for doctor's notes if they're out. You can't, you have to let them take the time without really giving you notice. And so it's easier when they're in two separate policies, you have vacation and sick, then you can treat just the sick hours with those regulations, like not asking for a doctor's note, allowing them to take the time when they need to. And then you can allow the vacation hours to have more like your practice regulations around it, where you have to request it 1 month in advance. It rolls over and I pay it out and all of those things. So again, just keep that in mind. If you're in a state that does not have sick leave, probably a PTO policy is easier because you don't really care why they're out. They're out. But if you have sick leave, it's better to do two different.
Cool. Well, if we did not get to your question, please feel free to email us at webinars@henryschein.com. We'll route your question to the HR for Health team. But I definitely want to thank everyone for their participation tonight, whether the questions or the poll. Kind of a different webinar for us. I thought it was kind of fun. I learned a little bit. Hope everyone did as well. Again, the recording will be available within 1 week of tonight. So yeah, thank you all for joining us and have a great evening.
Thank you.